All right, everybody, welcome. It's 11:32. Sorry, we're a little bit delayed. We had some technical issues. We got sorted out now. My name is Eric Tonsul. I'm one of the POA shareholders at RMWBH, and Sipra Boyd is joining us also. Sipra is also a shareholder in the POA department. And today we're going to be talking to you guys about restarting the DRV enforcement after COVID-19. What we're going to do is we're going to run through the presentation, which should take probably about 45 minutes, somewhere around there. And at the end, we're going to answer questions from the attendees of this webinar. If you have a question that you want to submit to us, at the bottom of your screen, there should be a Q&A box. If you click on that, type in your question, and then at the end of the presentation, we'll go through the questions and answer as many as we can. Again, we're going to shut this thing down at 12:30. So that being said, let's go ahead and get started. So I'm going to speak to you guys about basically just the DRV enforcement process, generally speaking. Sipra is going to address more of the COVID-related items. So first and foremost, what gives us the authority to enforce deed restrictions in the community? Well, we have our dedicatory instruments, also known as controlling documents or governing documents. And you'll see the list there. You have the plat of the subdivision, which the developer records in order to establish where the subdivision is located in the lots. You have the articles of incorporation, also now known as a certificate of formation. Those are the same thing. There's just different nomenclature that changed a couple of years ago. So the articles and the certificate are the same thing, and that establishes or creates the association with the state. And then you have your restrictions, known as the declaration, CC&Rs. You also hear that as well. That sets forth the restrictive covenants that are enforceable in the community. Then you have your bylaws. Bylaws pertain to the corporate governance of the association. There's often a mistake. People refer to the deed restrictions as the bylaws, and they're two totally different documents. I just want to be clear on that. But the bylaws address like your annual meetings, your board meetings, the terms for directors, quorum for annual meetings, that kind of thing. Again, the corporate governance of the association. Your deed restrictions or your declaration has your restrictive covenants that apply to deed restriction enforcement. Then you also have architectural builder guidelines. Those are guidelines that explain and or clarify existing restrictions in your declaration. Guidelines cannot create, amend, or remove restrictions in the declaration. And then you have rules and regs, kind of the same thing. Those are more, again, addressing what owners can and can't do, whether it be in a single family or townhome or condominium situation. So restrictive covenants, they can either state an action that is permitted to be done on a piece of property, or they can state an action that can't be done on a piece of property or is prohibited on a piece of property. And so basically it's, what you can't do. We all know this. I mean, and so that's, again, that language is in the declaration. And so that's where the authority comes from. Next slide, please. Thank you. So examples of restrictive covenants prohibit non-residential uses of property, like commercial uses of property, garage sales, that kind of thing. Prohibit multifamily occupancy, require improvements to be maintained. In this picture, you see a fence that's leaning in a state of disrepair. So that's the kind of thing that can be enforced. Requires architectural review prior to the construction of, let's say, an improvement to a home, whether it be an add-on or somebody's building a new home altogether. And issues that are taken into consideration are harmony of exterior design with other structures in the neighborhood. For example, we have a lot of older communities that were developed in the 50s ranch style homes, and the owners want to maintain that look. And then you have some owners or new owners that want to come in and build these 3-story monstrosities, which in another subdivision may be perfect and look great, whereas in others it would really stick out like a sore thumb. So that's an example of that. And then of course, harmony of colors. Most people don't want to have an avocado green house with, pink polka dots, that kind of thing. So those are just examples of what can be regulated through architectural review. So for the governing documents and the declaration in particular, the owners will usually have the right to enforce all use restrictions on the properties. What do I mean by that? I mean, if an owner is complaining about his neighbor, something in that backyard, in the in the neighbor's backyard that this owner finds offensive. But in order to see it, he has to, go up to the second floor, stand on a toilet on the second floor, and peek out his window in order to see it. Well, that's not going to be something that is really going to be a nuisance or annoyance to the rest of the subdivision. It may very well be a nuisance and annoyance to that neighbor, but not everybody else. And so what the declaration will allow is for an owner to actually sue another owner for a violation of the declaration. It gives them that standing to do it. Again, it needs to be in the declaration, but that is what that means. A lot of people don't know that. And this comes in handy with a lot of these neighbor-to-neighbor disputes that you managers have from time to time, where, example, I told you about the staying on a toilet. That literally, I got that question many years ago. And so in those situations, we can tell the owner, hey, look, this, we're looking out for the entire community, not just individuals. And usually the nuisance and annoyance provision in a declaration says it's a nuisance and annoyance to the subdivision. So if it's only affecting one person, that's usually not going to rise to the level of the entire subdivision. And so you can tell the owner that like, this is a neighbor-neighbor dispute. You have just as much right as the association does to file a lawsuit against this owner for violating your alleged violation of the declaration. Something that an owner cannot enforce are the lien rights that the owner has or the recovery of assessments. So if an owner is delinquent, another owner cannot sue that owner to enforce the association's lien rights or to seek to recover those assessments that have not been paid by that owner. And so again, and I already touched on this, does a violation affect the community? And that's what I explained with the neighbor-to-neighbor dispute. If it's a community nuisance, the association should probably get involved. Again, that's something that you should run by your association attorney and see what his or her opinion is on the matter. But if it's a private nuisance or a neighbor-to-neighbor dispute, that's, again, as I already mentioned earlier, that's something that probably, again, I would speak with your counsel, but more than likely the owner is going to be on their own to try to enforce that restriction. So pursuant to Chapter 202 of the Property Code, the association is acting under presumption of reasonableness. I'm going to just go ahead and read this very quickly. So a presumption of reasonableness is an exercise of discretionary authority by a POA or other representative designated by the POA concerning a restrictive covenant is presumed reasonable unless the court determines by preponderance of the evidence that the exercise of discretionary authority was arbitrary, capricious, and discriminatory. So I'll get to those last three words in a second. So again, right out of the chute, when you're filing a lawsuit, there's a presumption of reasonableness that the association is acting reasonably. However, if the homeowner alleges that the association has been acting arbitrary, capricious, or in a discriminatory manner, that could remove that presumption of reasonableness. So we'll go to the next slide and we'll discuss what those three words mean. So the first is arbitrary. Arbitrary is a failure to exercise honest judgment. Capricious is freakish, whimsical, fickle, changeable, unsteady, and arbitrary. And discriminatory, we all know what that means, failure to treat all persons equally. So this is the standard. And you'll often see a lot of times when owners get crossways with their association, they engage counsel. These are words that you'll commonly see in a letter to the association from the attorney, throwing it out there right out of the chute in order to try to combat the presumption of reasonableness right out of the gate. Again, these are words. These words, arbitrary, capricious, and discriminatory, are very strong, and there's a heavy standard in order to prove that, as far as that the board is really acting in that manner. But if the board is using sound business judgment rule, acting within the confines and the jurisdiction of the bylaws and the declaration, and is making an honest, attempt to enforce the restrictions uniformly and equally across the board, not making special exceptions for here and there, just because, this individual is a good friend of the board member, so we're going to go ahead and let that one slide. That would be an example of where you're being arbitrary or discriminatory. So again, so long as the board is acting in a honest, good faith manner of, in enforcing the restrictions equally across the board, that will be very good evidence that the board is not acting in an arbitrary, capricious, or discriminatory manner. Next slide, please. So with regard to the statute of limitations, there's a 4-year statute of limitations to enforce a deed restriction violation. So what does that mean? That means that from the date the association knew or should have known that a violation existed, it has 4 years to file a lawsuit if necessary in order to enforce the restriction. So let's say that there was a house that was painted, green with purple polka dots 10 years ago. And the board at that time just let it slide. They didn't do anything about it. And now, 10 years later, we have new board members and everybody's up in arms about this house. And they say, hey, Eric, we want to, you guys to send a demand letter requiring them to paint their house. Well, the 4-year statute of limitations has come and gone at that point. A demand letter can be sent asking them, but if they tell you to go pound sand, we're not going to do it. We can't file a lawsuit at that point because it'd be barred by the statute of limitations. I am aware of one case in Houston, this is several years ago now, where an association filed a lawsuit for a deed restriction violation that they knew was outside the 4 years, but they went ahead and filed it anyway. And the owner had counsel, and Exhibit A to the response to the lawsuit was a letter that the association had sent about 5 or 6 years prior with regard to that particular violation. And so they filed a motion to dismiss, and they sought sanctions against the association for filing a frivolous lawsuit. And the judge agreed with them. And the judge actually dismissed the case and awarded sanctions to the homeowner to the tune of $20,000 for filing a frivolous lawsuit. So it's a very important lesson that if you know for a fact that there's the 4-year statute of limitations has expired, do not file that lawsuit. It can land you a bunch of hot water. Now that obviously is a worst case scenario that happened in that particular case, and thankfully it wasn't one of our cases, but it's something that boards need to be aware of. And there's also defenses as far as latches, waiver, and abandonment of restrictions. I'm going to go into that here in just a second, talking about waiver in particular. So waiver, a defense to the enforcement of deed restrictions is an owner can allege that the restriction has been waived. And waivers acquiescence to such substantial violations within the restricted area as to amount to an abandonment of the covenant. So for example, if let's say there was 100 homes in the subdivision and 50 of the homes had a yellow roof, and the board decided, you know what, we don't like yellow roofs, we're going to start enforcing that. Well, because 50% of the homes in the subdivision have this yellow roof, there's a pretty doggone good argument that that restriction has been waived and the association can no longer enforce it. And also there may be changes in the conditions in the restricted area surrounding area, so it's no longer possible to secure a substantial degree of benefits to be realized through the covenants. And that's just kind of on an ongoing basis, depending upon the community and changes within the community. So with regard to waiver, you can either waive a provision, like in my hypothetical, if there's a restriction against yellow roofs and there's 50 yellow roofs in a 100 home community, good argument that that provision has been waived. However, if the association has never enforced anything within the restriction, and there's just all kinds of issues all over the place, or not issues, but all kinds of examples throughout the community where it's obvious that the restrictions have not been enforced for quite some time, there could be an argument that the entire set of restrictions are waived. So it could either be one restriction, it could be a couple of restrictions, it could be all the restrictions. It just depends. So that's why deed restriction enforcement is so important, because at the end of the day, you know, people buying deed restricted communities, you know, one of the primary reasons is property value. You know, if you have a community that's heavy on their deed restrictions and enforcement, and they're, you know, diligent about it, those property values are probably going to be much higher than a community that just lets anybody do whatever the heck they want. You may have, you know, junk cars or whatever. And so again, routine enforcement, diligent enforcement is important. And then lastly, with regard to waiver is, you know, would a reasonable person conclude that the restrictions had been abandoned based upon the number, nature, and severity of the other existing violations? So again, going back to my yellow roof hypothetical, if a reasonable person is driving down the street and they see 50 homes in this 100 home community with yellow roofs, a reasonable person would probably conclude that yellow roofs are permitted within the subdivision. So that's what that's referring to. So that concludes my portion of this webinar. And now my lovely co-worker Sipra is going to take it on to the end and address the COVID issue. So thank you for sticking with us.
Hi. Good afternoon, everyone. Thank you so much for joining us. Excuse me. Hopefully everyone's returning to some sense of normalcy, but happy to have y'all join us. I'm gonna, as Eric described, talk a little bit more about the technical aspect of deed restriction enforcement. this presentation is geared towards single family homes, but I'll also mention that there are condominium statutes in Chapter 82 that impact deed restriction enforcement. So just to dive right in, when we're talking about deed restriction enforcement, the association, again, single family associations and also condominium associations under Chapter 82 are somewhat limited in what they can do before they recover attorney's fees if they want to seek enforcement of a deed restriction violation. So where does that technicality in terms of the statute and that enforcement come from? The authority of that comes from Chapter 209 for single family homes. And on this first slide, we have this, the statute that gives us the authority. And it basically says that the association or its agent, and that's the management company, must give proper written notice to an owner before the association can suspend an owner's right to use a common area, file suit against an owner for basically enforcement of the deed restrictions. And it does exempt, and I'll talk about this a little bit later, suits involving the collection of an assessment or the foreclosure of the association's lien. The association has to send this notice before it can charge an owner for property damage or levy a fine for a violation of the governing document. So this is where the authority for enforcement comes from and the basis to recover attorney's fees. What does this notice have to say? So under Chapter 209.006, the notice has to be in writing and it has to be sent by some form of verified mail. What we recommend is certified mail because it has tracking information. You can actually have access to the USPS website to see if it was received, if it was attempted to be delivered, and that's all very helpful information if and when this notice is challenged. The notice has to describe the violation or the property damage. That's the basis of the suspension, the charge, or the fine. And then it also has to state any amount due from the owner to the association. It also has to inform the owner that the owner has a reasonable period to cure the violation, and that is only if the violation is of a curable nature, and I'll get into that in a minute. And it needs to really state a date specific for when the violation needs to be cured by, and that the suspension or the fine will be levied unless the violation is of an uncurable manner. So then for an uncurable violation, and I'll get into that, you don't have to give a reasonable time period to cure, or if the violation poses a threat to public health or safety. And that could be a range of activities, maybe fireworks, maybe firearms. We had an incident where, there was two homeowners that got into it in a common area swimming pool. So incidents that pose a threat to public health or safety. And you don't have to send a 209 notice if the owner was given notice and reasonable opportunity to cure a similar violation within the preceding 6 months. So if you've already sent one notice and it's a 209 notice under this provision that complies with this provision about the height of someone's fence because they put in an 8-foot fence and the restrictions require a 6-foot fence, then as long as it's been less than 6 months, you can proceed to the next step and you don't have to issue a new 209 notice. The 209 notice also has to give the homeowner a right to request a hearing under section 209.007 of the property code. And I'll also talk a little bit about the hearing process. They get 30 days to request that hearing. And then you also have to inform them that they have special rights under the Service Member Civil Relief Act. That's a tongue twister, sorry. So as long as the 209 notice complies with all of this, the association or the management company can send it out, and then the association can proceed forward with enforcement. So real quickly, the difference between uncurable and curable violations. Now remember, the main difference is in an uncurable violation, there's no reasonable period to cure. And that's because uncurable violations are violations that have occurred and they're not continuous. They're a one and done type violation. And the property code actually talks about examples of uncurable violations, such as shooting fireworks. Again, that language, if it constitutes a threat to health or safety. A noise violation that's not ongoing, which, if a house has a big party one weekend, the party's over, then there's no point in giving someone a reasonable opportunity to cure. Any type of property damage or holding a garage sale or some other event that once it's happened, giving them a reasonable period to cure is pointless. In the next slide, we talk about curable violations, and those are probably going to be the majority of the violations that you deal with. And so in your 209 letters, you're going to send to the homeowner, you're going to have some type of reasonable period to cure. Examples of curable violations are parking violations, maintenance violations, architectural control improvement situations, ongoing noise violations like the barking dog. Again, most violations where the homeowner is doing something that is ongoing and continuous and in fact needs to be stopped within a reasonable date certain. So in terms of the hearing that the association has to have for the 209 notice, the hearing, if the homeowner does request one, it has to be in writing. The hearing should be in front of the board or a designated committee of the board. And if the board has delegated that right to request a hearing to a designated committee, then the homeowner has to be informed that the decision of the committee can be appealed to the board. So it's our recommendation, to the extent that you can, any of those 209 hearings that are requested by homeowners typically be in front of the board, so you're not extending the process to then appeal that decision if it's in front of the designated committee. The hearing has to be scheduled within 30 days of the request. The homeowner obviously has to be notified of the date, time, and location of the hearing, and they need to be given 10 days notice before the hearing date. And it's really important, because this is all statutory, that the association comply with these requirements. So it's not to give the homeowner a reason to dispute the fact that the notice was either it was given but not handled correctly in terms of the hearing, and then the association therefore doesn't have the right to recover attorney's fees. In terms of the hearing, in terms of the 209 notice, I spoke earlier, the statute talks about exemptions for the 209 notice. And a lot of times this comes into play when there is ongoing construction, but these days construction happens so quickly, or can happen quickly, that you can go from having a fence one day to not having a fence the next day, or vice versa. In that situation, or if the construction is so egregious, let's say that the homeowner is building a home and has not received any architectural control approval, and the pace at which the construction is progressing is pretty quick, the association might consider filing for a request for temporary relief. In that situation, if the association is seeking a temporary restraining order or a temporary injunction, you're asking the court to immediately give the association emergency relief, because the violation is of an egregious nature. It needs to be stopped immediately. Because of the emergency factor of the violation, the property code says you don't have to give the homeowner a reasonable opportunity to cure or 30 days to request a hearing. You can immediately go down and seek that TRO or TI and still be able to recover attorney's fees. The 209 notice also does not have to be sent if there's a suit that includes the collection of assessments or foreclosure as a cause of action. There is a whole separate notice that needs to be sent for those types of actions, but we're not going to talk about that today. That'll be another webinar for some other day. Also under 209.007, either party may file a motion to compel mediation. So if that happens, there's no basis on which to send a Chapter 209 notice. And then if the association wants to temporarily suspend a person's right to use a common area, then it does not have to send the 209 notice. And essentially that's going to be something that causes some significant or immediate risk of harm to others in the subdivision. Again, think of my pool incident where two people got into an altercation. And so potentially at that point, both of those people would be suspended temporarily from using the pool, and no 209 in that situation is necessary. Now, for one of probably the most important parts in the whole 209 process and deed restriction enforcement process, why do we care about sending this 209 notice? We care because oftentimes, and depending on the type of violation, the attorney's fees for enforcement can become pretty extensive. If the homeowner is vigorously defending the cause of action, if there's some type of factual dispute about the violation, maybe there's a statute of limitations issue. And hopefully we would get to that point before we went down, too far into the litigation and incurred a bunch of attorney's fees, but sometimes you really just don't know. But what's really important in this whole process is to send that Chapter 209 notice if it's, again, not accepted, in order for the association to collect attorney's fees. That's the basis for it. As long as we provide written notice under Chapter 209 and a date in which the violation has to cease, and the association has followed the process of giving them a right to request a hearing, then the association should be entitled to attorney's fees. If the association doesn't follow that, then the association is not going to be entitled to attorney's fees. And there is case law out there, recent case law, that says because of the association's failure to send a Chapter 209 notice, in that particular case, the judge ordered that the litigation should be abated in order to give the association an opportunity to send the 209 notice, and then attorney's fees could only be incurred and granted for the association from that period forward. So the attorney's fees that were incurred up until that time to get to litigation were not something that the association could seek reimbursement for. Okay, so how does this all impact deed restriction violations, especially in the time of COVID? Assuming that you have the basis to pursue a violation, as Eric kind of dove into, look at your documents, look at your deed restrictions, make sure that there is a basis in your deed restrictions in order to pursue the violation. Make sure it's not just a private nuisance or a homeowner to homeowner issue. Once you know that you're on solid footing, make sure that you work with your management company, or if you're self-managed, that you reach out to your attorney and ensure that you're following Chapter 209. And again, Chapter 82, there are some provisions for condominium associations as well in terms of deed restriction enforcement that need to be followed, at least in the realm of being able to fine. So make sure you reach out to your attorney and you're following that process so that you can eventually recover attorney's fees if it gets to that point. If you've been a part of our past webinars over the past, I guess, 6 weeks or so, we've talked a lot about how COVID-19 is impacting homeowners associations, community associations, condominium associations, and their ability to collect assessments, as well as deed restriction enforcement. And pretty much what our position has been, at least in terms of collections, is to try and continue and operate as normal. And by that we mean proceed forward with attempting to collect your assessments. Assessments for most associations were due January 1 and delinquent January 31st. So quite frankly, before the whole country shut down in March, most homeowners would have had to have been obligated to pay their assessments. If for some reason a homeowner is impacted financially, then you're going to need to consider that impact on a case-by-case basis. There are millions of people that are out on unemployment. I know those numbers are shifting as of the latest reopenings in the country, and particularly the state, but you have to be mindful if someone comes to you for a hardship exception. That also really impacts deed restriction enforcement. Deed restriction enforcement to a certain degree, because people were limited in terms of shelter-in-place orders and potentially being able to find vendors that could, repair or replace whatever the issue is, maybe paint, maybe fix a fence. We were saying that the associations needed to kind of ease up on deed restriction enforcement. With the reopening of the state, we do think that at this point, associations can resume deed restriction enforcement as normal. There are still some limitations in terms of returning back to your office. There are also some limitations still in terms of social distancing. So again, be mindful of those when you are doing deed restriction enforcement drives. Certainly the same opinion and advice that we have for collecting assessments applies in the deed restriction enforcement arena. If a homeowner comes to you and they've been financially impacted because they can't cure the violation because of that financial impact, they need to come to you, maybe submit something in writing to the board for them to consider, and then the board needs to decide as a whole how it wants to proceed. As far as we know, statute of limitations have been told for a couple of months in the state of Texas, but in the grand scheme of things, as Eric mentioned, there is a 4-year statute of limitations. So we're talking about a couple of months, March through June so far, that potentially statute of limitations may have been told as a result of COVID-19. And if you're waiting till 3 years and 8 months or 3 years and 5 months before proceeding forward with deed restriction enforcement, you're going to have some issues on your hands. So again, we would encourage you to move forward as normal to the extent that you can, and to the extent that there's no hardship situation, because the only way to toll statute of limitations outside of some type of court order, maybe bankruptcy, is to file suit. So sending a demand letter, filing a notice of noncompliance, any other action short of filing suit is not going to toll the statute of limitations, and that's why it's important to proceed as normal to the extent that you can. In terms of deed restriction drives, we do think most deed restriction drives can happen in a car, and should happen in a car. I think management companies and associations are utilizing various interactive internet platforms in order to take pictures from their iPads or their iPhones and upload those, and then send deed restriction letters. So to the extent that you can continue that, that's what we are recommending. Don't get out of the car unless you necessarily need to, because ultimately we make reference to the May 5th order in this slide, and I know there's also a June 3rd order that's more recent, but essentially both orders are still recommending the minimizing social gatherings. Anything 10 and under needs to be the maximum of people that get together, and they're also still recommending social distancing at least 6 feet. So just keep that in mind during deed restriction drives. And then also any people that are in those critical categories, people over the age of 65, People with compromised immune systems, they're strongly encouraged to not leave home and continue practicing social distancing. So to the degree that you're impacted by anything in the governor's orders that might, expose you to risk, you need to potentially stay home, shelter in place, and not expose yourself just to do a deed restriction enforcement drive. So what are the takeaways ultimately in deed restriction enforcement? If the association and the management company can enforce deed restrictions by doing a drive inspection, then those are recommended. If you can minimize contact, that is what's recommended. The June 3rd order from Governor Abbott says you need to follow all the guidelines from the Texas Department of State Health Services. Again, minimizing contact with others and staying 6 feet apart. For photos, hopefully you can also do those while you're staying in the vehicle. Try not to exit the vehicle, maintain social distance and contact. Some management companies have moved to the process of having their own vehicles for these deed restriction enforcement drives. If you are part of a management company that has office vehicles, make sure that the company and you are taking precautions to sanitize the vehicle before you use it. Also, it'd be a good idea to sanitize it after you use it as well. And even if it's your own personal vehicle, it's amazing to me now that we're all aware, how many surfaces that you touch when you either exit a vehicle or just go from point A to point B. So be mindful of that, whether it's your vehicle or not. Take all precautions. And then to the extent that you can report the results of your deed restriction enforcement drive around, either in the car, through your iPad or laptop, or you can do it from home, which again, the governor's orders are still limiting office, the ability to go into office because you're still required to maintain social distancing and avoid high-touch areas. If you can do it from home, do it from your car, then continue to report the results from either your home or your car. If you need to go into the office, again, just make sure you're following your company's policies about that. All right, I think we've got about 20 minutes or so to open up for questions and answers. I think Eric had mentioned the way that we're going to try and field some questions. I know we had some questions at the beginning, which I think I addressed one of them. There was another question that we were submitted before the presentation, essentially about the effectiveness of a 209 letter. If the association sent a 209 letter pre-COVID and it's been on hold, the violation's been on hold for 3 months or however long the shelter in place order has been going on, then should we send another letter? And my suggestion is absolutely, as a courtesy, it would probably make sense to send another letter. Just remember that a 209 letter is good for 6 months. So if it is older than 6 months or it's been longer than 6 months since you've sent a 209 letter, you do have to send a new one before you can, again, go down the process of enforcement in terms of recovering attorney's fees. All right, let's turn it over. We can open it up to question and answers. I see one. How do you feel about hanging door hangers for deed restriction violations? I'll answer that, and Eric, feel free to chime in. I'm not a huge fan of getting out of your vehicle and going onto someone's property for deed restriction enforcement. I think that potentially risks the manager, the association, the board member, whoever is doing the deed restriction enforcement to potential liability for trespass. There are some associations that have restrictions that say you're not liable for trespass if you perform some type of self-help remedy, and that's only generally after notice to the homeowner. So from a liability perspective, it makes me really nervous for anyone to go onto someone's lot for purposes of deed restriction enforcement.
Yeah, I agree, Sipra. And also, you know, there's some cuckoos out there. You enter their property without their invitation. It could get confrontational. So for all the reasons you said, I 100% agree. Door hanger is probably not a good idea, and especially right now with COVID going on. You know, if somebody's entering your property and putting something on your door handle. You don't know who's doing that, and that just not a good idea right now. No. Are there any other questions?
I don't see any other questions in the chat section. I'll ask Kyle and Lindsay if they've received any others.
I don't see any more. We'll part now. Again, thank you guys for joining us. I hope this was informational and educational for you guys. And as always, you can reach out to us whenever you need to, if you'd like to. If you have more detailed questions, obviously, Sipra and I and Cliff are in the Houston office. Clint, Brady, and Leah are in our satellite offices in Austin and San Antonio. So thank you very much for joining us. And y'all have a great day. Stay safe. We'll see y'all soon.
Thank you, everyone.